Good morning. So on Wednesday, I received a call from a client that I've been working with for the past 18 months. And he said to me he was just sentenced. He just had a sentencing and received a sentence of 24 months. I said, Jeff, do me a favor, remind me, wasn't the government asking for something like 60 to 70 months? He said, yes, got a great outcome. He said, but I should have gone to trial. And I said, why? He said, well, if you remember when I first came to you, I was just charged and I was going to trial, and you warned me about the risks of going to trial. And I really think I could have beat them and I could have won. And when I went in there, my attorney said, don't worry, you're going to get a great outcome. Hopefully you'll get home confinement. But I got 24 months and I am livid, and I really should have gone to trial. And I remember earlier this week, I saw a post that Larry had written, I guess a little while ago, about the trial penalty and the risks of going to trial. So I asked Larry, could we sit down, especially given this call I received, and can you better explain what that is and the risks associated with it?
Okay, super. Yeah, so it's a very informal thing called the trial tax. So technically, if you decide to take a plea instead of going to trial, the technical biggest risk you have is not getting the 3-level reduction for acceptance of responsibility and demonstrating remorse. But the reality of it works a lot differently. First of all, when just going to trial, right? A lot of people, he has a little bit of buyer's remorse on the plea agreement, but he forgets that even completely innocent people lose at trial. The thing is that when you go into a trial, you're dealing with a jury that's being weaned off of 20 plus years of law and order and CSI, thinking the government can do no wrong. And even if they suspect that you might not be guilty of that charge, they figure, well, the government charged him, he's got to be guilty of something, right? And on top of that, the government goes to great lengths to bring a number of charges. All you have to do is be found guilty of one to get the penalty. And even if you're found guilty of more than one charge, frequently the judge, or almost always the judge, will have those charges run concurrently. So you only got to be found guilty of one thing. I remember there was one friend of mine. He had gone to trial, and he was found guilty on one charge out of 26. Out of 26, one charge. So oddly enough, one of the jurors called the attorney afterwards to thank him on the great job that he did. And so the attorney asked the juror, well, then why did you find him guilty? Well, they said, and this was the response of the juror, well, we felt like we had to give the government something. Little did that juror, or those jurors, understand that that something could have been 10 years. The person ended up getting 3-year sentence, but he shouldn't have gotten anything. The fact that jurors will go and do that, it's a misunderstanding of the system. And one of the reasons that happens is during trial. Any point during trial, no attorney, nobody is allowed to mention what the defendant is looking at in terms of what their sentence could be should they lose a trial. So that's a big problem with it. The second thing is that the system is biased towards wanting to get people through it very quickly. The government has a 97+ % success rate. There's a reason, because people understand that if you go to trial, you could get double or triple your sentence. 2 people that we were time with in prison. One was a doctor, one was running a call center. They had both been offered 1-year plea deals. One guy had a mistrial in his first trial, thought he was looking great into the second one, and got sentenced to 12 years. Could have pled out and gotten one. Another one was a doctor, Armand. I don't know if you remember him, right? Same thing. He was innocent. He knew he was innocent, but he lost a trial. And just losing a trial, there's a presumption against you. And here's some other pitfalls you could be looking at, besides losing that potential 3 levels for acceptance of responsibility and remorse. If you testify at trial, or you bring up evidence at trial that the judge deems was wrongful, then you can get extra levels in your sentencing, 2 for perjury and 2 for obstruction of justice. That's 4 additional levels. Depending where you score out, that can be many, many years of your life, just because you were trying to defend yourself. So the whole concept of innocent until proven guilty has really been turned on its head. It used to be that we were a country where we'd rather set 10 people free than send 1 guilty person to prison. Now it's just been turned on its head to just the opposite. More than happy to send innocent people to trial. And even when you go to plead out, or you want to plead out, we had a friend of ours, I don't know if you remember him, Ellie, may have preceded you, but they were looking to go after his boss. He was working as an accountant at this big real estate firm during the real estate crisis. and they offered him a plea deal, and they wanted him to be a witness against his boss. He said, sure, I'm willing to be an honest witness. And the prosecutor turned and said, no, we're looking for a motivated witness. So these are the kind of things you're looking at when you decide that you want to go to trial and plead guilty. Now, that said, there are some instances where you will go to trial, or people have gone to trial, some of our clients, and they've received what we would estimate to be a similar sentence to what they would have received had they pled out. In fact, we had one incredible case. Now, this is a total outlier, where a doctor went through the trial. The government, he lost the trial, was found guilty. The government was asking for somewhere in the neighborhood of 12 years. You attended that trial.
Yes.
And the guy ended up serving 2 hours that afternoon in the marshal's office because the judge realized what a farce the situation had been. But that's by far the exception as opposed to the rule. So this trial tax, unfortunately, is very real. Some federal judges have spoken out about it, and they've been ostracized because of it. Because in many senses, the federal criminal justice system is orchestrated theater. I can't tell you how many people I know who have been giving take it or leave it plea agreements, and then you have to go into the courtroom and the judge says to you, do you understand everything in the plea agreement? Do you agree to everything in the plea agreement? Now, you may or may not, but you have no choice but to say yes, otherwise you will lose that plea agreement and the benefit of it. So it's a whole myriad of issues that pertain to the trial tax, but which is why in almost all instances, you get a much better deal when you plead guilty as opposed to going to trial.
So I said to Jeff on Wednesday, do you remember we prepared you for your pre-sentence report? You and I actually did it together in the middle of last year.
Right.
And he said, yes. I said, well, if you remember, I believe you qualified for the RDAP program. He said, I do believe I do, and the judge recommended it. So I said, depending upon how things play out, you should be out in less than a year. And all things considered, I understand you're upset, but you have to put things into perspective. And as upset and as emotional as he was, when I spoke to him again yesterday, he said, I thought about it, and I thought about the inherent problems that I could have faced, and I just want to put the matter behind me. So thank you for watching the video today. Again, as I encourage everyone, reach out to Larry and I, call, text, email us. We're going to try to do a different topic every week now that Larry is going to be joining us for these, and I appreciate your time.
Thank you.